Stream. Manage broadcast. Give me one more second here. Okay, no, this is not for kids. And okay. Are you ready?
Ready.
Okay, let's go ahead and. Oh, this is scaring me a little bit. This is over here to the side. I'm hoping that once. Hold on one second. I'm sorry.
You're good.
I'm supposed to be good at this. Yeah, that's up there. I'm just hoping that shows on the monitor. It's not showing right here right now.
Oh, okay.
Maybe I gotta go like this. No.
There you go. And then change this preview. There you go.
No, but that's not in the thing. That's just the zoom.
Oh, okay.
Okay, I'm hoping it's gonna go like that. All right, I'm gonna give it a shot. Manage broadcast. Okay, I'm gonna give this a shot. Here we go. No, it's not coming up. Darn it. What is going on here? All right, Nathan, I'm sorry. Hold on a second here. I'm going to have to get engineers up here.
You're good.
It's not. Why isn't that showing up? Oh wait, maybe I need.
Yeah, pull that in.
Oh wait, maybe I need that.
Mm-hmm. You might want to keep that because the site is like.
He needs to take me down then, because I gotta. It's not coming in the box here.
Pull that.
So I see our camera.
Pull Nathan into the full view. No.
He's not picking up. So we've got the Zoom pulled up, but it's not. I need that in the screen. I'm clicking on Zoom capture, and it's not getting it in.
All these others are.
Wait, did that do it? That may have. Did that?
I don't know.
Well.
Is it?
On. Oh yeah. Now it's in there. Okay. I think that's it. Now. I just couldn't get it in there.
I don't see any difference. Oh, there you go.
Yep, there we go.
Go.
Okay,
There we
Nathan,
go.
are Nathan, are you good to go now? Good to go now?
Yeah.
I think we got it. We got it. Oh my goodness.
Awesome.
Okay.
Good.
Let's go ahead and give this one more try. Okay, I'm gonna start stream. And tell Jared he's going to have to put in the description for me as well. I lost it. I'm going to go ahead and create this now. Okay, welcome back to YouTube Live. Thank you everybody for joining us on day 3 of the trial for Kouri Richins, the woman who stands accused of killing her husband with fentanyl, poisoning her husband with a fentanyl-laced cocktail. I'm once again joined by Nathan Evershed. He is a defense attorney not associated with this case, joining us every day to help us break everything down. Nathan, I'm just going to go ahead and jump right in. A very short day in court today. What stood out to you the most?
Yeah, it's just a single witness, a really important witness, a person that breaks down the scene, one that where you're able to walk through the house, that was able to show where different things were located, where the kitchen was, where the bedroom was, where the body was located. So a critical witness, gathering evidence, putting evidence in storage, and those things.
So one of the things that stood out to me, there were a couple things that stood out, but court was short considerably. It started a little late, and it only went for about an hour. And then there was another long break, and then the judge said, "We need to stop for the rest of the day because of a scheduling conflict." And so we only got about 1 hour worth of testimony. We reached out to the state or the county prosecutor said, "We don't know exactly the reason, but we trust the court." Has a good reason for court ending. So that was a little unique, I thought. But the one person that you were talking about that took the stand today, her name is Chelsea Gipson, and she is essentially the main evidence person here for the whole case. The defense called her the evidence lady. All of the evidence from the case falls underneath her purview. She had a chance, or the defense had a chance to cross-examine her today. Her testimony started yesterday, so she was cross-examined by the defense today. And the defense attorney started asking a lot of detailed questions about where she was, what she took pictures of. And one particular thing of importance was the defense referenced a bed sheet that was underneath the bed near where Eric Richins' body was. There was a sheet draped over the body, and then there was a bed right next to his body. So I do have some sound from that testimony. I'm going to go ahead and play that right now, and then we'll talk a little bit more about it. So here's that exchange right now.
Up under the mattress that has no sheet on it, that's the sheet that he was pulled to the ground on?
I believe so.
Right. And did you examine that sheet before it was put into evidence?
I don't recall how much I examined it, but I looked at it.
Do you still have that sheet in evidence?
Yes, we do.
Right. And is there any blood on that sheet?
I believe there was on this.
So if there was testimony here by EMTs that blood did not start coming out until after the EMTs were there, is it fair to assume that the sheet was under Mr. Richins when the EMTs were working on him?
Can you rephrase, like, the sheet
underneath him? Let me ask this way. Why did you feel that that was an important piece of evidence to gather and keep?
Because it was where he died on.
And that is where the defense attorney says, okay, that's what we need. Thank you very much. So what do you take from that exchange?
So broadly speaking, what the defense is doing is that they're putting in the two big words of reasonable doubt into the minds of the jury to say, well, because the state says that a certain thing happened, that the poisoning happened in this case, it really could have been anything. And so what they're trying to do with pointing to different things and different aspects of the case, including sheets and other things that we'll be talking about, that's, broadly speaking, they're introducing, there are different theories, this wasn't well investigated, different ways that he could have died, and there's nobody that could say, in fact, this was a homicide.
So really what we're seeing is the defense starting to lay the ground for reasonable doubt is essentially what we're looking at right now.
Absolutely, and that's their job, and that's what they're poking and prodding towards, and that's exactly what their theory is going to be.
So to that point right there, we're going to play another piece here. So to set this up, the defense is again talking to this witness and questioning her about what this evidence did, what she saw, what she took pictures of, what she did not take pictures of. Because one of the big questions, according to the prosecution's case, is that there was this fentanyl-laced cocktail that Courtney allegedly gave her husband, and that's what ended up killing Eric Richins. And so this line of questioning is centered around alcohol, around any potential drugs that may be in the house. And remember, this evidence was there at the home shortly after Eric had already passed away. So this is the exact same night. Here is some of that exchange. Let's go ahead and listen to that now.
You noticed there was liquor bottles in the cabinet in the kitchen downstairs.
I believe there were some. I'm not sure about how many, though.
Did you ever photograph any of those?
If I did, it would have been in my overall photographs.
Also, the day of the death when you were taking photographs, did you photograph anything in the kitchen trash?
No, I didn't photograph the kitchen.
All right. Did you notice anything set around the kitchen? For example, cut up limes or drink mixes or anything on the counter? Did you notice any of that?
I didn't enter the kitchen.
Never even went in it?
No.
Thank you for...
Okay, so what do we take away from that? Is that sowing doubt in the jury's mind that if there was this fentanyl-laced cocktail, you've got the person that's in charge of all of the evidence of this case saying, I never saw any of that. I didn't even see limes cut up or mixed mixers.
Yeah, you can't guarantee too much in a trial, but I can guarantee you that this is exactly the line of argument that the defense is going to play in their closing argument. Like, ladies and gentlemen of the jury, they believe that this was that there was a beverage that was laced with fentanyl, and guess who could have found that, ladies and gentlemen of the jury? They could have. And guess who never even looked in the kitchen? Ladies and gentlemen of the jury, they didn't. Okay, and why wasn't it there? Because it really wasn't there, etc. Now, of course, the prosecution will have their response to that, but that's what they're creating, is that, well, had this been a better investigated case, had this been more thorough throughout in the entire house, not just in the bedroom, more evidence would have been obtained, but this wasn't, and that's reasonable doubt. You shouldn't punish our client because this was a poor investigation. That's going to be their argument.
So as the defense was wrapping up their cross-examination, the next line of questioning that they got into, they were very calculated words that they wanted used and the words that they wanted the jury to hear. So this line of questioning was centered around phone calls that this evidence was recording between Kouri and her family members. And again, the defense wanted to be very specific about which words were said and which words were not said. So I'm going to go ahead and play that right now.
It's between Ms. Richins and her family that you obtained recordings of.
Can you clarify?
On about a weekly basis there for a while, were you downloading calls between Kouri Richins and her family?
Are you talking about jail calls?
Your Honor, move to strike and need to approach.
Okay, so now when the attorneys approach the judge, there's white noise that's played sidebar. For those that are unfamiliar with what happens, that's where only the attorneys and the judge can hear the conversation that they're having. And coming out of that sidebar immediately after, before anything else was done, here is what the judge looked at the jury and told the jury. I want to go ahead and play that right now.
Time. There are legal issues that come up that I need to discuss with the attorneys at sidebar. This will happen throughout the course of the trial. There's no particular significance to any one of them. Second, please do not consider or speculate at any time during this case or during your deliberations about whether the defendant was or is in custody or was in custody at any time. That is not evidence of anything. You cannot consider that issue for any reason. Ms. Nister, please proceed.
Thank you.
So what we have here is the defense attorney being very calculated about the words being used in this line of questioning. The witness says, you're talking about jail calls. Sidebar. We need that stricken from the record. Let's talk about this. The judge comes out and says, you need to not assume that she was ever in custody, that she's in custody. What do we make of that exchange?
One of the fundamental groundworks for all of the criminal justice system in all of the United States of America is the presumption of innocence. And how courts have looked at that over the years is that the person that's sitting there at the defense table has to be presumed innocent and have to really look innocent. So that's why you don't see individuals like Ms. Richins, who is literally in jail as we speak, coming out in a jumpsuit. It's also important to know that when it comes to like jail calls that, hey, she wasn't necessarily in jail, because that's not relevant to the analysis. What's relevant is that these recordings came out and that this was being followed through. And so it's really important. The judge had to make the right ruling, and he did, clearly, like teaching the jury that it's regardless of where you think she was or where this happened, disregard that. What's important is just the words and the conversations and the recording, maintaining that presumption of innocence. And that's one thing that's really important, Jim, here to remember, is that what can happen from here, there's going to be an appeal. If she's found guilty, there will no doubt be an appeal. And so you have to resolve these issues during trial to minimize any issues for appeal. It's in everyone's best interest to do that. And the last thing any judge wants is some big presumption of innocence failure that happened during trial.
And so does the judge, is that common in trials where the judge will stop proceedings and talk to the jury and instruct the jury right in the middle of proceedings?
Yes. It's like all of this evidence, all of these exhibits, all of these witnesses, it's very common just to instruct the jury on certain things that come in, because they're just trying to maintain the legality and the authenticity of any kind of conviction, because there is going to be an appeal and they want to make sure that everything's clean.
And it was shortly after that the judge said, okay, we need to break for the day. I'm going to be back in an hour. An hour later, he said, nope, I got to be done for the day. We'll be back here at 8:30 this morning. The jury members to not talk about the case, not watch anything about the case. They were done for the day. That was pretty much it. So in just about an hour, like you mentioned, a very key witness. We did find out some new information. Was there anything else that really stuck out to you? I mean, that was kind of the crux of what happened today.
And investigation, that video, seeing that video 3D through the home, really, really enlightening. I've never seen that before. I thought that was terrific. Really good display on what the evidence looked like and what was going on. I think the jury has a really good understanding as to what that home looked like and where things are at. So it was a well-presented case.
So I won't say 3 days in, even though we technically are. There was only about an hour today, so a little more than 2 days, I guess we should say. We will be right back here again tomorrow. Thank you as always for time with us to break this down. It's a very complex case. It's really just getting started. Trials have lasted 5 weeks. So if you want to go ahead and subscribe